Courtrooms can get quite intense at times, but nothing compares to the tension in court when the judges go against the most terrifying defense teams. So getting right into it, nothing is more terrifying than the defendant himself being his own representative. Here we have Darrell Brooks. He has caused mayhem during his trial.
I don't care about the inevitable. It was already written from day one what was going to happen. It doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have not been.
Please sit down.
And then Your Honor, and then you always make it seem like you always make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm waving this for like 20 minutes saying I would want to come back. I'm doing this.
You're here now.
Can I come back? Can I come back? Can I come back?
So sit down.
It wasn't honored. And then I said, okay,
finish.
I'll write this and I'll see if Your Honor can see it on the screen. The objection sign saying, I've exercised my right to be present.
If you stop for a minute,
I have the order of the court?
I'll explain it, but you have to stop so I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain.
Another defense team that has caused problems recently is the Parkland shooters defense team. They're quite immature and very pushy.
You know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Miss McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I didn't
even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. Before this court to allow that kind of testimony is also...
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now.
The judge in this next clip did not let the defense attorney get away with his horrible attitude.
I'm in Batesville and I'm calling Billy every time, and they do it without me. And I know it because they show up at my house. Metal detector, cut the barbed wire fence, look for the gun, go to the lake with Billy and throw the gun away. Shotgun shells, wire clippers, everything. It's all the same, and it's been the same literally for 10 years. Through 20 interviews.
Objection, Your Honor. This characterization of 20 interviews. That's the proper argument to your argument. You may proceed, Mr. Okay. I'm sorry, Mr. Perry, did you say something?
I didn't say a word.
I told you about that attitude. You would not, under your breath, be disrespectful to this court, sir. You argue things he has a right to answer. When I overrule your argument, whatever you said down and said, of course it is. It is a proper. Mr. Perry, it's a proper argument to your argument. You may proceed with that.
Yes, sir.
The judge in this next clip put the defense attorney in his place for overstepping.
Objection, Mr. Shellhorn.
Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before any shots were fired.
I don't even know what I don't even know what the factual basis is for that.
Judge, I can ask the witness.
No, you can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not.
There's no evidence that it happened before. None. Not a scintilla of evidence on the record so far that supports that question.
If a witness says that something happened, I can't ask them if...
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't, Mr. Belinkus, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident, according to the expert reports. So that's not a factual basis for you.
This next defense attorney really knew how to stand his ground. In a case like this, it's not comforting.
Well, please, the court, Your Honor, we have a motion to compel, we filed, we heard on it, and then if they want to respond, Your Honor, obviously will hear that. We filed this motion weeks after they failed to comply with Rule 5 and Brady, and just ignore that. I think that's a disservice to this court and the criminal justice system.
The only reason why
Your Honor, I'm not judged. If I could be heard without being interrupted and hijacked by the state as they continue to try to hide the ball on this case, I'm sorry if I appear upset, but I can tell you that every time we turn around, they're trying to hide something. And if we could just have 15 minutes to address the court and call a witness, we could get to it.
Your Honor, to set the table appropriately, I think the protective order, which is what started this whole issue, is the way to set the table. And I would point out that Mr. Harpoon stood up and interrupted me as I was trying to set that table.
Your Honor, that table has never been set. They won't comply with Rule 5. They could have raised this protective order issue 7 weeks ago and didn't do it. So
that's because the defense agrees with that until after
again, if I would be allowed to finish without being interrupted, I know he's had a mistake like grand jury. I know he's a very important guy. But my client has a right to a fair trial, and a fair trial means a motion to compel to find out what it is we're trying to compel and not have the Attorney General continue to try to hide behind whatever this is.
Another defense attorney that is terrifying is Mark O'Mara. He always puts up an interesting argument.
There is no other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. That violent act in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds and receiving additional injuries consistent with, and even the state's own experts said it was consistent with, my client's head being bashed against concrete. To date, and the state's case is now done, to date, they have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence.
One of the many big court cases this year was Amber Heard and Johnny Depp's trial. Amber's defense attorney was not a quitter, but this ex-TMZ employee gave her a taste of her own medicine.
Then you wouldn't be a witness, correct?
Objection. Calls for speculation.
Sustained. Sustained. Next question.
I'm not aware. Okay. You know this case is being televised, right?
I am aware that there are cameras.
And so this gets you your 15 minutes of fame, doesn't
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself kind of in a target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical. Thank you.
Now, are you aware that Mr. Depp's attorneys were well aware of the TRO that was going to be presented on May 27th?
Objection. Calls for speculation.
Were you aware of that?
Lack of foundation.
Overruled, if you can answer it.
Can you restate the question?
Were you aware that Mr. Depp's divorce attorneys were aware that Amber Heard was going in to seek a TRO on May 27th?
I don't think I understand the question. I don't think so, no.
Okay. Do you know whether Blair Burke, one of Mr. Depp's divorce attorneys, had a very close relationship with TMZ at that time?
Objection. Calls for speculation.
Overruled, if he knows.
I was not aware of that.
Okay.
Casey Goro has got to be one of the scariest attorneys, and this video proves it.
Twin Peaks, Your Honor, that contains information that is exculpatory and that seriously undermines the state's theory of prosecution.
First of all,
Excuse me.
I'm going to object.
May I finish?
No, I'm going to object to the statement right there. These interviews happened after the Twin Peaks shooting. Any assertion of otherwise would just be a flat lie.
Well,
may I finish? I'm sorry. Make the record, Judge.
You may make a record.
Thank you. There are 2 interviews with this particular individual, one prior to Twin Peaks and one after Twin Peaks.
Judge, I'm going to object. That's a misstatement of the facts.
We can play them in open court, but the point, Your Honor, is that this district attorney's office, including Mr. Jarrett and Ms. Dillon and Mr. Reyna, are sitting in a room where witnesses 2 years ago, 2.5 years ago, are making exculpatory statements. And they say that they don't have possession of the recording, but they had actual knowledge of the contents of the recording. And I'm happy to recite page and verse, Your Honor, of the witnesses and the statements that they've made that frankly should have prevented the state from sponsoring the testimony of all 3 of their quote-unquote experts and would have materially changed my cross-examination of every witness that has testified, save for the first young woman who was a waitress at Twin Peaks. No, she was a cook at Twin Peaks. I mean, I don't know how this isn't Brady, and it is certainly willful. And that fine line of saying, well, we didn't have the recording, you were there. They were physically present in the room when those statements were made.